Hey guys, welcome back. Before we even step into the courtroom chaos, you need to understand what you're about to witness here. This isn't just another routine arraignment. It's a live collision between courtroom procedure, self-representation, and a defendant who clearly believes he can argue his way through legal structure without counsel. From the very beginning, the judge is doing what the law requires: advising rights, explaining bond, and setting expectations. But what makes this case explosive is not just the charges. It's the defendant's repeated interruptions, emotional responses, and refusal to fully grasp procedural warning.
All right, I'm Magistrate Garwood. I'm going to be handling your case today. I'm told that you did not want to speak with the public defender.
No.
So, in this circumstance, at arraignment, everyone has the right to have counsel present to assist them for your first court appearance.
Okay, that's why I didn't need anyone to defend me, because it's my first court appearance, because there hasn't been any problems.
Okay, but it's your first court appearance, and today the court's going to advise you of your rights.
Okay.
I am going to go through the charges with you so you understand what you've been charged with. I'll give you your next court date. I would appoint counsel if that's something you would like the court to do. That would be at little to no expense to you. And then I have to decide what to do as far as bond and bond conditions. Conditions are things the court tells you can and cannot do. If you violate a condition, you're subject to immediate arrest. The amount of your bond, that's whether you have to post something in order to be released. That's an evaluation I'm going to be making today.
Okay.
So are you sure you don't want to talk to Ms. Anderson? She's an attorney. She's been an attorney for a really long time. I'm guessing you're not an attorney.
No, I didn't break any laws, and I've never heard.
Well, you've been charged.
I've been charged falsely, though. I have already called the police several times and explained this whole situation. Just like Haniel has called the police and explained that I look like her ex that hit her.
Okay, so here's the thing. First, I'll advise you of your rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. So you're going to want to be careful about what comments you make. Second, you have the right to an attorney. If you can't afford an attorney, the court will refer you to the local appointing authority. In that circumstance, Ms. Anderson would assist you today, and then the public defender would be able to assist you going forward. You also have the right to a trial. At a trial, a jury or a judge would be able to decide whether you're guilty or innocent. This is case YPD 25-6642. So would you like to reconsider and speak with Ms. Anderson?
Before I make a decision, is whatever I choose, is it going to be a reason for me not to be able to go home and get out today? I understand whether I want an attorney or not.
An attorney is not going to hurt you at this point. An attorney is going to help you at this point because they understand the law and they understand the right arguments to be making regarding bond. I can tell you the prosecutors are requesting a cash bond. So they're requesting that you have to post $25,000 to be released from jail. So it's probably going to help you if you talk to the public defender. If you don't want to, I can't force you to talk to her, but she's here.
And if I don't, then I won't be able to get out without a $25,000 bond.
Well, you'll have to make your best arguments on why I should release you.
Okay.
So what do you want to do?
I'll say what I can say for it to be released. I need somebody else to say it for me. I mean, I know the law too.
You know the law?
Yeah, I'm not a lawyer, but I went to.
This moment sets the foundation of the entire hearing. The court is clearly explaining a fundamental constitutional right, the right to counsel at arraignment. The judge is not forcing representation but emphasizing protection. What's important here is how the system is designed. Even if someone thinks they don't need a lawyer, the court still offers one because early legal guidance can completely change case outcomes. But instead of accepting or fully engaging with that safety net, the defendant immediately tries to justify self-representation.
That is a misdemeanor charge. It carries a maximum penalty, 93 days in jail, and or $500. Do you understand what you've been charged with?
No, because this charge is false. It's not.
Okay, hold on. That's something
I never put
different.
my hands on it.
Hold on. That's disagreeing with the charge. Do you understand what you've been charged with? I understand you're saying you're innocent. It wasn't you. You didn't do it.
Okay.
But for today's purposes, you've been charged with this crime. So do you understand what that crime is? Or do you need me to go back
I
through it?
understand what you said, but I'm just saying it's false.
That's fine. So you understand what you've been charged with. Do you understand the maximum penalty?
Yes.
All right. I'm going to have you stand mute. That means you'll remain silent as to the charge. I'll enter a plea of not guilty on your behalf. I'm going to schedule you for your next court date. That's going to be a pretrial that will be in person in front of Judge Barr. He will be able to see you on June 5th at 9 a.m. at the 14A2 District Court. Yes.
The problem is I still have 4 daughters and bills to pay. I need to be able to go to work. How am I gonna?
We're not there yet. I'm just giving you your court date.
Okay.
Okay. So in person at the 14A2 District Court, June 5th at 9 a.m. in front of Judge Barr. We'll send you a notice to appear at the jail. The next thing we'll need to address is bond. There are 2 parts to bond. Bond conditions, those are things the court tells you you can and cannot do. If you violate a condition, you're subject to immediate arrest. The other side of bond is whether you can be released today on your own or whether you'd have to post a bond in order to be released. Before I make any decisions regarding bond or bond conditions, I will hear from Ms. Landy, who I think you still need to put your appearance on the record. And then I'll be happy to hear from you. But again, I want to remind you, anything you say can be used against you, and you do have the right to remain silent. Ms. Landy, your bond arguments?
Thank you, Your Honor. Ashley Landy for the people in this case. Your Honor, has the court had the opportunity the court took the swear to in this case, correct?
Yes, we did that this morning.
Thank you. Your Honor, I am requesting a cashier surety bond. I am also further, I believe, requesting a GPS. I have to pull up my notes here. In this case, the allegations include the defendant remaining in the victim's home, not leaving when being asked to leave, going into her bed and touching her under her clothes. The victim did not provide additional details for us to be able to look at charging a CSC in the 4th degree. However, there is sufficient evidence to charge the domestic violence as they had previously been in a domestic relationship, a dating relationship.
Here we start seeing the first real tension. The defendant is denying wrongdoing outright, but the court is making something very clear. Whether he agrees or not, charges have already been filed. This distinction is crucial in criminal law. Denial does not pause procedure. The judge carefully reminds him of his rights again, including silence and counsel. But what stands out is the defendant's attempt to explain his version of events in real time. This is where many self-represented defendants unintentionally weaken their position, because anything said can later be used in bond or trial proceedings.
You will be able to make your bond arguments, but again, I want to remind you, anything you say can be used against you.
Okay, I have permission to speak now?
You do.
Okay, so what I'm saying is, me and Haniel have never been in any sort of violence whatsoever. Not even one time. And she's called the officers before and explained that has nothing to do with me. So because I don't understand why is all this necessary? Because the last time I called the cops and had a welfare check done on her because she wasn't answering, I was worried about her, and the cops came and arrested her. So why is all this information just gone? Nobody knows, understands. They're not helping. They just come and try to accuse us of hurting each other, but it's others that's hurting us and taking from us.
So you do have a criminal history. I mean,
No,
what's your date of birth?
No criminal history.
So you pled guilty to an assault and battery.
Yeah, because they said I have kids and house payments and responsibilities to take care of my family. And how am I supposed to do that being in jail for months to be able just to go on
Pled
trial?
guilty to attempting to assault, resist, or obstruct a police officer.
Yeah, I know I had to because I didn't need to be in jail where I can't even take care of my family. That's the reason.
Well, regardless of why you did that, you have a criminal history. That's just the fact of it.
I would never hit a woman anyways. I never said I wouldn't leave, but I said I was leaving. She's told me not to leave until you guys got there, so she knows I'll leave because other people that she's been with, because she dated several guys that look like me, because that's who's just her preference, I guess. But even I've never told her I would not leave. I would not do that. I don't want to be somewhere I'm not wanted. She wanted me to come there. I said I can't stay here.
I would encourage you to stop talking. Because now you're talking about what allegedly took place on that day. If you can keep talking, but you may make the prosecutor's case for them by saying what you're saying.
I told her that I can't stay until until the police come, because even if I do, they're just gonna arrest me because you already know that I'm not supposed to be here. How is she gonna let me? I only went there to give her money. I gave her money when I went there.
Is there anything else you want to say before I proceed with your bond conditions and bond amount?
No, that's all. I was saying, I'm sorry. She probably was just having a bad day. It's not. I would never hurt her. I love her. I love her with all my heart. I care about her.
Okay.
If she's sick, I go get her medicine or ask her if she wants something that would make her feel better, or say I'll get whatever she needs to be happy or.
Okay. I'm gonna have you stop talking because again, you are saying things that I do not think are going to help you in this case. Your bond conditions are as follows. You're going to be required to have standard supervision at our community corrections department that will include drug and alcohol testing. Each time that you are required to test, you'll have to bring photo ID and $12. If you don't have photo ID, then you'll be able to ask the jail for a copy of your booking photos. No alcohol, no illegal drugs, and no marijuana. Do not leave the state without prior permission of the court. Do not purchase or possess any firearms, ammunition, gun components, or any dangerous weapons, nor are you to be with anyone who has any of those items. Do you own any of those types of items?
No.
Do you understand your conditions so far?
Yes, but am I allowed to say anything else?
I'm not done.
Oh, okay.
Do not assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. Do you understand?
Yes.
You're to have no contact with. When I say no contact, no direct or indirect contact with her, no telephone, email, texting, internet, or social media, Skype, Zoom, FaceTime, Facebook, Slack, Discord, Instagram, Snapchat, TikTok. No contact means no contact. Don't direct anyone else to be in touch with her on your behalf. Don't mail anything to her. Don't deliver anything to her. Don't have anyone else do what you're not allowed to do in reference to contact with her. Do you understand?
Yes, of course.
You are not to go to Huron in Ypsilanti. If that is your home address, you must find another place to live and you must notify the court of your new address within 24 hours of your release from jail. We will give you a phone number that you can contact. If you need to return to that address for a civil standby, you'll be allowed to do that. A civil standby allows you to contact the police. They would meet you there. They are there to keep the peace. That is not an opportunity for you to hang out. That's not an opportunity for you to communicate with Hanel. That's just an opportunity for you to get your things and go. Do not go without the police. Do not go to any home, temporary residence, work, school, or house of worship of Hanel. Do you understand?
Yes.
Do not violate any criminal law. You're required to appear for any and all court hearings and other places as directed by the court. All of your conditions, they will exist whether you're in custody or out of custody, and they'll remain in full force and effect until changed by the court. If there's any change to your address, email.
This is the turning point. Bond discussion begins and reality starts to hit. The prosecution is pushing for serious financial conditions, while the judge is still trying to guide the defendant toward legal representation. What makes this segment important is the judge's warning: attorneys don't just represent, they strategically argue bond conditions, something the defendant clearly does not fully grasp yet. This is a classic courtroom moment where legal strategy versus emotional self-advocacy collide.
With her. It's not
No,
just.
I know, I understand, but she's the one that called me to ask me if I'm okay.
Again, I encourage you to not talk about what specifically happened on the day.
Tell me I have mail or.
See, this is a good time when having an attorney would be useful to you, because you could ask those questions of your attorney.
Okay. So as of now, based on what I told you what happened, is there any way I'll go home, go like to one of my relatives' house today?
So you're welcome to post the bond that I'm about to tell you about, and then you can go home to a relative's house. So this is what the court is going to do. Based upon the facts that are alleged in this case, it's of concern what was presented to the court, and potentially additional charges could be coming from how I heard the testimony. I am going to set a cash bond in this matter. That is going to be $10,000 cash or surety, no 10% privilege. I believe that is appropriate in this case.
Can it be a personal bond?
That's not a personal bond. You would have to post $10,000.
But why is
And
that?
I am going to require the defendant to have a GPS tether to make sure that he doesn't go back to that address prior
There's
to
no reason to go
release.
back to that address. I never said I wouldn't go back, not go back.
I'm going to have a GPS tether placed on you. They don't place tethers on holidays or weekends, so that tether would not be placed until Tuesday.
I just don't understand why am I being ignored? She has a mental disability.
I'm talking. I'm not sure what's so complicated.
I'm not mental health or a drug addict or anything, so why are you guys saying this?
All right, I'm going to mute you if you keep interrupting me. So the tether can't be placed on the holiday or weekend. The tether would be placed on Tuesday. That's the next time the agents are here.
I have work Tuesday. Why you guys want to make me lose my job or something?
I'm not making
I know
you.
that's necessary. It's the holiday weekend.
So because it's a holiday, if somebody commits a domestic violence, it doesn't count?
If somebody makes a false accusation because I look like one of her exes, it's not up to you guys to do a proper investigation and get more proper information from both of us.
Again, an attorney would be most helpful.
Somebody that doesn't have a mental health condition.
So your bond, hey, I'm not deciding guilt or innocence. I'm just deciding what bond conditions are necessary to keep everybody safe. You've demonstrated to me an inability to control yourself because you keep interrupting me, which is rude and inappropriate in this circumstance. You did it to Ms. Londi as well. So I have to consider your ability to control yourself and follow my court orders. And that gives me concern that you can't do that either. So the bond is going to stay $10,000 cash or surety and a tether prior to release. Ms. Londi, anything further?
No, Your Honor.
All right, you're all set, sir. You can stand up and go to the door. Thank you.
So there's no way I get to go home unless I pay $10,000.
Right, and get the tether, and you can't get your tether till Tuesday.
So even what if I don't have $10,000
Then you'll remain in custody until your next court date, which is June 5th at 9 a.m. So that is next week on Thursday.
And that's because I said I wasn't guilty. Well, I don't understand.
Of course not. That has nothing to do with whether you said you were guilty or not. That has to do with.
I spoke out of line, but I didn't raise my voice.
Do you want me to answer your question, or do you want to just keep interrupting me?
Anything wrong.
Do you want me to answer your question, or are you just going to keep interrupting?
What am I interrupting? Nothing I said is stopping you from understanding my side of what's going on. Or
if every time I talk, you start
listening
talking
to you or being disrespectful or nothing. I didn't mean any disrespect towards you or anybody.
This is one of the most critical psychological moments in the entire hearing. The defendant claims familiarity with the law, even jokingly comparing himself to lawyers. The judge responds with controlled humor, but the underlying message is serious. Legal education is not the same as legal practice. This moment highlights a common courtroom pattern: overconfidence in partial knowledge. Judges see this often, and while it may sound humorous, it can seriously damage credibility during bond hearings. What's unfolding here is not just disagreement, it's a mismatch between perception and legal reality.
All right, Mr. Vaughn, we're here today because you have filed a number of different motions, and I want to address those motions with you, give you an opportunity to be heard. So if you want to come to the podium, since you are representing yourself, I will deal with each of those motions. First of all, let me advise you that in April of this year, you sent a notice stating it was to the judge of record, stating that on the 15th day of April 2025, I have some concerns that I wish to speak to you about before I file papers in your court. I'm letting you know this isn't a request for advice. It concerns actions by your staff of the courts and yourself. With the utmost respect, I write this ex parte letter. If we can meet in private, I will. If I can't meet in private, I'll file it publicly and the order will be noticed. I could not speak with you privately because of the rules of conduct for judges. So the first notice or first motion that you have filed has been a request for a criminal record, and states that you're requesting the courts to move the state to furnish the defendant with a copy of a prior criminal record per Rule 16 of Discovery and Inspection, Rules of Criminal Procedure. If I understand correctly, you're asking for a copy of your criminal record?
Yes, all them requests, the motion discovery is supposed to provide all that anyway, so that summing up half the motions. I mistakenly filed them separately.
That's fine.
Some of them.
You're entitled to discovery requests. Here, when you have a lawyer, a lot of times what will happen is the lawyer will be given access to the electronic system that the DA's office has implemented, where all of the discovery information, all of the evidence is loaded into an electronic system that then the defense lawyer can access that defense. Now, you don't have that ability representing yourself, so I'm going to order that all of the evidence in Mr. Vaughn's case needs to be put into written form, hard copies, and he needs to be provided with that.
Judge, the problem with that is going to be that there are videos from his arrest. One of his charges is retaliation for past action. And so there are videos from the officers in the jail at that time. And that's going to be one of the largest problems in providing that to him.
No, sir. That's not a problem. I filed a civil suit years ago. They provided me with the DVD, and it was my issue to deal with after that. And they allowed me to go into the office privately, view my own case, to fight my own case before, so that is not an issue.
Sounds like he's got it solved.
Okay.
You provide him with a DVD or a video on a compact disc, he'll access it as he needs to at the jail.
Okay.
All right, when is this going to be? Because I've been doing some of this since 2021. I'm tired of coming here looking at y'all. Like, this is going on for a minute. This is getting ridiculous. This is my first. I still ain't got a motion yet.
A motion?
I ain't got a motion yet. All the attorneys I had, all the public defenders I've had, nobody have provided me with nothing yet.
Okay. Well, I'm going to deal with all of that today, because you're going to get written discovery. You're going to get a copy of any videos so that you can look at them yourself. How long will it take for him to be allowed? His trial date's in September. How long will it take to get the hard copies of the written discovery? All right, we'll have it within.
Ben, she should have it today.
We'll have it within 10 days. Okay. You have a second motion, which is a motion to remove your counsel. Mr. Spratt was appointed as what is generally referred to as elbow counsel. You want to represent yourself, and I've granted you that opportunity. I've also appointed Mr. Spratt to assist you in representing yourself, so that he can, because...
Now the formal charges are presented, and everything becomes structured and procedural. This is where courtroom reality fully locks in. Dates, locations, statutes, and penalties are officially stated. The defendant's immediate reaction is denial, but legally, the judge must proceed regardless of disagreement. This is a key legal principle. Charges are not debated at arraignment, they are acknowledged procedurally. The judge carefully redirects him from emotional response to procedural understanding, reinforcing that the court is not determining guilt here, only processing legal status.
For two, Mr. Spratt, since December, has had a sickness or illness going on, which is on record in Humphreys County Jail, where he never could show up out there. I called 2 or 3 times. I should have had the motion discovery he just handed me.
All right, well, that's part of life, that people have illnesses and sickness. I am going...
Not for a month and a half. I'm sorry, sir, excuse me, but not for a month and a half. I mean, he ain't able to help me.
Well, I'm of the opinion that Mr. Spratt is able to help you with this because he is only elbow counsel. You're representing yourself. I will order that the discovery and motions that are filed in his court need to be sent directly to Mr. Vaughn rather than a copy to Mr. Spratt directly to Mr. Vaughn so that he gets a copy without having to wait for his co-counsel. No, you just have to mail it to him and he'll receive it. So I'm denying at this time your motion to remove counsel because I think it's important for you to have someone at trial to help you with that. I've ruled you're going to have access to the discovery directly. You're representing yourself. Mr. Spratt's role is as elbow counsel to assist you in, the trial itself.
Well, what about the fact that he couldn't even come to Waverly? How are you going to get to Decatur?
I'm going to appoint Mr. Spratt. You want to address any of that, Mr. Spratt?
I will, Your Honor. I'm not sure of what illness I had for a long time. I was sick back during the holidays. I did just hand Mr. Vaughn his discovery in case number 2021 CR 462. My understanding is the state wishes to proceed to trial in 2022 CR 336. There is no discovery that's been provided to me electronically for that case. When I did finally feel better and go to see Mr. Vaughn, he had been transported to West Tennessee, and I just simply have not been able to make it down there with my schedule. But he does have the discovery, or the written discovery. I did not give him the electronic discovery today because of reasons which he's now clarified.
Well, I told you that too when we talked on the phone. Me and you done been over that.
Let me hear from Mr. Spratt. This is not a time for you and him to discuss.
I mean, I'd be happy to mail him a DVD of anything electronic for that case that I have. I only have discovery for one case.
He needs the discovery for the case he's going to trial on, so let's make sure that that discovery is provided to him.
Now we shift to prosecution strategy. The state is requesting strict bond conditions, including high cash bond and GPS monitoring. This signals that the prosecution views the case as high risk in terms of victim safety and compliance. What's important here is how prosecutors build bond arguments. Not just facts, but risk assessment, behavioral patterns, alleged conduct, and potential future contact. This is also where courtroom tone shifts sharply. The judge is no longer just advising rights. It's now about balancing liberty with safety concerns.
I believe that complies with the request for speedy trial that was filed. It is the first available date that we can put into play according to our rotation of judges and our schedule that we have. That is the first available day. The September date does, in my opinion, comply with your request. The case won't be continued, so we'll need to make sure that it is ready for trial on that day. The remaining motions that you have filed are all motions for discovery, which I think you had mentioned before, and I think we've now addressed that. So he's set for trial on September the 19th, is that correct? That needs to be shown to be first on the docket.
Excuse me, sir.
Docket, so that we'll go to trial. And let me address this. You filed a motion to recuse, notice of recusal or request for the master clerk, and you're asking to recuse or to somehow recuse the clerk of the court and there is no basis, that you have no basis, you have no standing under the law to ask this court to disqualify the clerk of the court. I understand your reasons for why you say that, and I have addressed the problems that you're saying you've had thus far with receiving copies of things, and that's going to be mailed directly to you. The court file will have it reflected that you are to receive all of those as lead counsel in your case, and I am not of the opinion that you have a basis in law or in fact to remove or ask for a recusal of the circuit court clerk, so that motion is denied. In addition to that, you had a motion to recuse the court recorder, and again, I have no idea why you would allege that there is a reason for that, but I don't find any basis for removal, or that you have standing to remove the court reporter. She worked for me, and under that basis, I don't find there's any reason.
Well, then me and you have a conflict then, because you was on there doing the same thing they was doing. You want to put this on YouTube and not act a professional? Y'all want to make jokes in here? And then they don't want to file the paperwork? How am I going to get a fair trial here?
You're going to get a fair trial because you're going to be tried according to the law and the facts, and a jury of impartial people who know nothing about your case will make the decision.
So if I want to make an appeal and she ain't recording it, how are we going to do that?
She will be recording it if it is a felony case. There are certain times when the cases are not recorded, or if we're on break, it's not recorded. But
well, we wasn't on break because look, I just walked out the courtroom and I said something after we went on break. You said omitted, and she said, "Well, I ain't got to omit it." She said I wasn't recording no way. So how can I appeal something if y'all taking it out of the record without me being present during the proceedings?
Well, first of all, I don't recall any such thing that.
Well, go back and look at the video.
I'm not required to go back and look at the video, Mr. Vaughn.
This case ends with a clear judicial outcome: strict bond conditions, cash bond requirement, and GPS monitoring. But the bigger takeaway isn't just the legal ruling. It's how courtroom behavior directly influences outcomes. We saw repeated interruptions, emotional escalation, and refusal to fully engage with legal counsel. And while the court remained procedural and controlled, every interaction contributed to the final decision regarding restrictions and bond severity.